Good evening. We are here with Real Talk number 5. Why should we care about family division? I am Hilary Bendick. I'm from Grassroots Justice. It is an organization located in the South Hills, primarily out of Dormont, and I'm with Stephanie Myers, who I'll let introduce herself in just a second. And we have Alyssa Cowan, who is an attorney with Allegheny County Children, Youth, and Families. Also Judge Elliot Howsie, who was appointed to the Family Division in 2019. And Sabrina Korbel, who is the legal director of the Women's Center and Shelter of Greater Pittsburgh. So I'm going to start with Alyssa. You are in my first box in the top corner. Why don't you go ahead and introduce yourself?
Hi there. Good evening, everybody. My name's Alyssa Cowan. Thank you so much for this opportunity to speak with you tonight. I'm really excited about the conversation that we're going to have and the opportunity to really just give everyone a chance to learn more about this race in the Court of Common Pleas for 9 openings, as well as to learn more about the hard work that we're doing in the Family Division. I am an assistant county solicitor with the law department representing children, youth, and families in the Family Division. And I come to the law through social work. I was a practicing social worker and I have my master's degree in social work before attending law school, and really want to bring trauma-informed perspective to the courtroom and to ensure that all of our families interacting with the courts are treated with dignity and respect, and that we really get to the services that can best meet their needs and solve the problems that are bringing them into the courthouse in the first place.
All right, and Sabrina, can you please go ahead and introduce yourself?
Yeah, that's great. Thank you for this opportunity. So my name is Sabrina Korbel, and I am the legal director at the Women's Center and Shelter of Greater Pittsburgh, which is a law project within a domestic violence agency. And there are 13 or so of those law projects across the Commonwealth of Pennsylvania. But in my work, I have managed and provided free legal representation to domestic violence survivors in the Family Division primarily, and in over 7,000 cases. And we know, the reason I'm excited about this forum is because we know that the Family Division is the highest volume court division in Allegheny County. It handles the most cases. Many of the people who come through the Family Division do not have representation and have to figure out the court system on their own, and it leads to a great conversation I hope we have tonight about accessibility. I also, would like to say that about 30% of our cases that come into the Family Division have domestic violence involved with them, including the 4,000 PFA, protection from abuse cases, that we handle every year. So I'm excited. There's a lot to talk about. Hilary, you and I have had conversations over the years. I'm excited about this, and I hope we get down in the trenches a bit, and we make some great suggestions for things we could do to keep going with improvements in our division. So
great, looking forward to it. All right, Judge Howsie, go ahead and introduce yourself.
Hello, thank you for this opportunity to participate. Definitely appreciate it. My name is Judge Howsie, and I am currently serving in both the Family Division and the Criminal Division, where people from low-income communities typically end up in that court system, and there are just so many opportunities to improve upon the work that is being done in the court system. And I'm just eager to continue to play a small role in that progress and that movement towards reform. I previously was employed as a judicial law clerk for Superior Court. I've worked as a prosecutor, prosecuting child abuse cases. I've worked as a defense attorney, and I've also had the privilege and the honor of serving as the director of the Public Defender's Office. So have a bit of information and knowledge about the court system, but I'm definitely interested in learning more about ways in which we can continue the work of reforming our court system and making it accessible and better for the people that grace the front steps of the court system. So I'm looking forward to participating in the discussion. So thank you again for the opportunity.
All right, great. And Stephanie, Moore obviously brought us this program. So why don't you go ahead and tell us about Moore, who brought us here today?
Sure, I'm Stephanie Myers. I'm a member of MORE, the Mount Lebanon Organization for Racial Equity. We're coming up on our first anniversary. We are working towards police accountability and anti-racism education. And I'm really happy to have our panelists here, our guests, and happy to be here with Grassroots Justice Representative Hilary. Thank you. Thanks everybody for joining us tonight.
All right, so obviously we were here and we're talking about family division. Judge Howsie, as the official judge on the panel, why don't you go ahead and tell us what is family division, the sections of family division, what all happens in family division?
So family division involves matters obviously involving children and family. There's an aspect of the family division which pertains to juvenile delinquency and juvenile dependency. And then there's also adult family where issues related to custody, divorce, and protection from abuse actions occur. So that is family division, and that's pretty much, those are the areas that are the focus of family division.
Okay. And Alyssa, you are an attorney, obviously, with children, youth, and families. So in dependency court, can you explain how a case starts? What's the first proceeding where possibly, a child or children might be removed from the home, and what analysis would a judge be making for that to occur?
Yes, absolutely. So dependency is the part of our Juvenile Act that refers to what we more commonly understand as child abuse and neglect issues. So these are our cases that are looking at issues of child abuse and neglect. And these cases come into the court via phone calls made to children, youth, and families directly or to Childline. Many of us have done trainings as mandated reporters. The mandated reporters were expanded in the 2016 changes to the Child Protective Services Law. So I think there are a lot of mandated reporters now in the community, people who are soccer coaches or a youth group leader at a church are now complete those mandated reporter trainings and become mandated reporters. Our most common mandated reporters that we get phone calls from are schools and hospitals and doctors' offices. So the agency will receive those phone calls and then need to screen those calls in or out for investigation, just depending on the facts of what's provided in the phone call. A caseworker will be assigned to investigate the case. And they use tools that have been developed by the state, risk and safety assessment tools, where they look at the individual risk factors that a family has and that a child has. So maybe a very young child is a risk factor, a nonverbal child, a child with special needs, the specific injuries that might be at issue, the neglect issues that may be at issue. Is it an issue of children who haven't shown up to school for 3-4 months? Is it an issue of a child who was born but then never had any interface with any medical provider for 6 or 7 months? And what's going on with that infant? Is it an issue of substance use issues? And so based on those risk and safety assessments, a caseworker then needs to, and they don't make it alone. So caseworkers never make these decisions on their own. They team them, they staff them with others within the agency. So that staffing will take place and a decision will be made whether or not a child needs to be removed in order to protect that child's safety. Once a decision is made to remove, that's when we have absolute court involvement. That's when the court needs to be involved. Sometimes there are cases where the agency will file a petition on that don't involve removal. We think the child can be safe, but we still think there needs to be court oversight to get some things done. But when there's a removal, that's our first hearing, which has to happen within 72 hours of the removal, which we call a shelter care hearing. And a judge is responsible for ensuring that clear necessity is shown for that removal. And there's testimony, but that testimony is hearsay testimony. Hearsay is admissible at that proceeding. And it's really kind of the initial proceeding. The parties do have the right to have attorneys present at that hearing. So their right to counsel does kick in at that hearing. And then they can have their full adjudication hearing. Statutorily, it's supposed to be scheduled within 10 days of that shelter hearing. And that's when there's the full trial where we have the rules of evidence apply and judges need to ensure that hearsay is not, what we're looking at that time. time. And for our adjudication, the county has to prove those dependency issues by clear and convincing evidence, which is our highest standard that exists in the civil world. And so that's what judges are looking at those stages of the process in terms of the legal barriers.
Now, you mentioned both having the children remain in the home and then having the children be removed from the home. In both circumstances, what services would be available that a judge would be able to order for the parents or parent of the child that might assist that parent in either maintaining the children or having the children be returned to the home?
Yeah, so a judge is also responsible for looking at all stages of the proceeding to see if there were reasonable efforts made to prevent the removal during that first stage proceeding. So the agency does need to show that there were attempts made to put services in that could enable for the children to stay home so that they wouldn't have to be removed in the first place. So it's really important that judges make those inquiries of the caseworkers and the other witnesses who are testifying, asking the parents, were any services offered to you? Did anyone offer to speak with you about getting a drug and alcohol assessment and whether there was an in-home drug and alcohol provider that could be dispatched to your home and provide services in the home and allow your child to remain at home, or for you to go to a place with your child to receive drug and alcohol treatment? So that's really critically important that judges are asking those questions. And some of those services can be drug and alcohol services, what we call in-home services, which is a large umbrella term for really having a high number of hours in the home to work with a family around like housing issues or food insecurity issues, or what is it that are barriers in terms of getting a child to school, mental health services, ensuring that we have connections made for mental health services, and really taking a close look at the specific needs of a family and working to come up with some solutions to those needs at that first stage and then ongoing as we move throughout the court process.
Okay. According to a 2017 CYF report called Race and Disproportionality in Allegheny County Child Welfare System, a review of the referral sources of children indicated that Black children are disproportionately referred to CYF for investigation. And they were also investigated 1.3 times more than white children, accepted for services 1.5 times more than white children. Now this report was obviously, it's now a few years old, but my understanding is that these disproportionate stats still exist. Is there a role that judges can play in ensuring that these referrals to CYF are not as a result of implicit bias or possibly even racism? And what role, could judges play?
Yeah, so that disproportionality still does exist. Unfortunately, it is an issue that's still facing us in the child welfare system and in the court system. And all throughout the process, it's really important that everybody is engaging in these conversations to say, hey, okay, are we looking at some clear, concrete, objective factors? Are we making a whole bunch of subjective observations and assumptions about what's going on with a family and not really looking at something? And are we treating families differently? Are some families being held to a different standard than other families are? And what can we do to address those issues? Judges have a really critical role to play in that process. I think it's really important to ensure that there are multiple witnesses. So not only the caseworker testimony going on in a hearing, but also family members, neighbors, other people who see this family from all different aspects of their life and can provide some other information about the family except for this 1 or 2 time encounter with a CYF caseworker. We really need to make sure we're understanding the family's functioning as a whole and not just getting one person's perspective. When we're relying on one person's perspective, we're also relying on that one person's biases, prejudices, assumptions, and we can't do that. We can't be making decisions all based on what the caseworker has to say, even though the caseworker has an incredibly important job. Judges need to take the time to hear from those other witnesses and to get that full picture of a family's functioning, to figure out if they are involved in the system appropriately and fairly, or if they are being screened in because of, our society's larger issues with racism, implicit bias, and definitely people get caught up in the system as a result of that. And I would also include in that, especially our immigrant families. We have a growing immigrant population in Pittsburgh, and a lot of times we still have a ways to go in Pittsburgh in terms of working with our immigrant neighbors and understanding them. I've lived in DC and Philadelphia and Atlanta, where it has had larger immigrant populations than Pittsburgh and more immigrant resources available. And we're still lacking in a bit of that here. So especially when we're working with our immigrant families, we need to work even harder to make sure we're working to get a fuller understanding and not just our one lens of our own one experience. We really need to hear from a number of people involved.
And if I may, and I think that's why diversity is so important: diversity of perspective, diversity of background, racial, diversity, ethnic background. Because what one group may look at as being problematic, or it may be different from the way that they're accustomed to dealing with the situation, and they have deemed that inappropriate. It may not be inappropriate; it just may be different. Different's not always bad. Sometimes it's just different. And the concern and focus needs to be on the safety of the child. And I recently had a case where the caseworker was involved with the children, and the father was extremely angry because of some poor decisions that the mother had made that put the children in a bad situation. And he was vocal about his displeasure about the mother's decisions. And the caseworker interpreted that as him being hostile. And it wasn't that he was hostile, it wasn't that he was aggressive, it wasn't that he was a bad parent. He was angry and he was frustrated that he had to jump through all of these hoops and deal with all these bureaucratic red tape, not due to anything that he had done, but due to poor decisions that the mother had made that placed the children in a precarious position. So I think we have to be mindful that, just because someone is being outspoken about their displeasure, just because someone is being vocal about their position or their assessment of a situation, does not in and of itself disqualify them from being a suitable placement for the children. So I think we do have to question and continue to ask questions and understand what is behind that decision to refer those children. What's pushing that? What's driving that? Is it because there's a legitimate concern about the children's safety, or are there other issues at play? And that's a question that needs to continue to be pressed whenever presented with those factors. You have to always ask the caseworker or the referral agent, referring source, why are you concerned about the child's safety? What is going on here that has brought you to a place where you feel that there's some intervention that needs to be done that may even result in the child being removed from the home?
So that actually brings up a good question. It was going to be my question a little bit later on, but I'll ask it now because it brings it up. I think diversity and family division is probably the most important divisions for diversity. And I would be curious to know your choice. And Sabrina, since the question hasn't been fielded to you, what do you think about diversity of the bench? Because I think that because we are dealing with families, and often, within their home, what is going on, especially in adult court, to me, it just seems diversity of the bench is just so important in family division of all the, different divisions.
Yeah, I mean, we're absolutely at a moment in time where we should be changing the way our bench looks, and the way our bench has a diverse understanding of the law and the families that they've worked with, right? And I agree with you. I think that is the division that should be most inclusive, be most diverse, not only in terms of gender and race, but also in terms of, as the judge said, backgrounds and true life experiences. There are so many folks who come through the family division who have such a variety of lived experiences, but also have a variety of interactions with the court and how they've experienced the court, if they've had to be involved in a juvenile case, or be involved in a custody case, or be involved in a divorce. And we need to have a bench right now that listens to those experiences and that makes people feel engaged in the court system. I think when people complain about their experience in family division, it's that they didn't think their voice was heard, or they didn't think that someone understood their lived experience. And this is the chance to change that. We are at a moment in time. I absolutely believe that. And that goes exactly to the question that you just asked about implicit bias, pushing people who are testifying in cases to better understand why they're taking a position, how the case got there before them. And if I have a second to sort of transition back to the first question too, I think that, one of the things that would really help in these cases is getting more people to be able to testify in court. And we've really seen that during the pandemic. While the pandemic has showed us all the gaps that we have in terms of accessibility, it's also shown us where we can make real improvements. And, when you're trying to figure out whether a family should be involved in a dependency case or not, and you're trying to figure out whether a caseworker has done all of their investigative background, you're only getting that information. Prior to this, a lot of times you were getting your information only from that caseworker because people couldn't come down to court. Teachers couldn't come down to court. Counselors couldn't necessarily take the day and spend that whole day in court. Coaches, neighbors, all the people that Alyssa mentioned, right, didn't necessarily have the ability to come into court. And with remote access through Zoom or Teams, we can now hear from a lot of different people who are involved with families and get a wider, broader picture of what's going on than we were before just getting a single report from a single caseworker. And I didn't want to miss an opportunity to say that, because I think that this accessibility conversation is also very important in addition to the diversity conversation.
Okay. We had a question, and it's from, let's see here. It says, in terms of continuing conversations and judges taking the time to receive the whole picture, what are your tangible plans at the onset of dependency matters / shelter hearings to ensure that CUF workers have gathered the necessary information before removing a child from the home versus only having gathered perhaps one-sided information?
And just to expand on what I was saying, because it sort of addresses that question, which is that, in the cases that I have worked on in the last year in the juvenile division, what we're seeing is that this expansion of remote accessibility goes beyond just the courthouse steps, right? So if we're asking parents or children to participate or to meet certain goals in order to move their case forward and be reunited as a family or stay together as a family, we were forcing families to battle against childcare obstacles and transportation obstacles and availability and costs. And so people weren't able to meet these goals that we were placing and piling on top of them, right? And so what we've seen now is that not only are families able to participate more in their court case remotely, but then they're also able to participate with these services remotely. And we see families being able to access and achieve their goals more than we were necessarily in the past, because they were facing all of those obstacles. So this is an expansion, I think, of the court back into the community, and how, we're making, and that's where we need to take our courts back into our communities, right? But we're allowing people to get connected to resources by not demanding it of them and setting them up for failure, but by giving them more options to achieve the goals that the court is asking them to achieve. And it's not just how they come into the court, it's how the court is making folks go back into the community. And I think we need to keep that up. This is where we expand on that and we keep going.
Okay. Did you want to comment, Alyssa, on that? Sorry, no, she came off mute.
No, that's okay. Yeah, no, I completely agree with Sabrina. We really need to make sure that we just don't leave what we've learned, the positive that we've learned from this time behind when it's time for the courts to reopen, and we just kind of go back to the old ways that weren't always working the best for families. And the way that I envision it, I would love to see things going forward. Is that we do need to see people in person, right? We need to see people in person in court at times. And there are some trials that are really difficult to do remotely, but our check-in review hearings, to be able to keep those remote still, so we are cutting down on the number of trips that families are making downtown, would be incredibly beneficial. And the same thing with their service providers. Not every encounter with their drug and alcohol treatment provider has to be in person. It can be a hybrid combination of both in order to alleviate some of these stressors and pressures on our families that we're trying to serve. And then just, I think back to your question in terms of what can we do to make sure that we're at that initial stage, ensuring that caseworkers are doing their work that they need to do to prevent a removal to begin with, is really just making sure that we have, judges on the bench who really care about these hearings, are willing to put in the time and the effort and energy to asking all of the questions that need to be asked in terms of what groundwork had been done prior to walking into that courtroom. And there's a lot of work that can be done prior to walking into the courtroom. And it's important that people are prepared, and it's important that judges set that standard of, when you walk into my courtroom, you need to be prepared to ask these questions. I definitely, just in my work as a solicitor, my caseworkers know what questions I'm going to be asking them in my direct examination of them. And, it's the same thing. They need to be prepared to know what the judges are going to be asking of them and what the judges' expectations are.
But I think as judges, we can't just do what we've always done. We can't just do this, maintain the status quo. We can't just accept the referral or the call, the ECA from the caseworker because there's a concern, and so we'll approve it because that's what we've always done when we get those calls. We need to ask the difficult questions. We need to push back. We need to make sure that there's a basis and make sure that the caseworker has done his or her due diligence, because the decisions that you're being asked to make have far-reaching consequences. So you need to have as much information as possible, and they shouldn't be made in a vacuum. And you should have as much information as possible to make that decision, to make an informed decision. And I think sometimes we do what we've always done when it comes to certain matters, certain groups of people in our court system, because that's just how we've always done it. And so you have to have people who understand the consequences of the decision. You also have to have people who are informed enough to understand that there's more to the story, and does it make sense to take that course of action that you're being encouraged to take. So I think far more has to be done if you intend to stop this disparate treatment that consistently occurs in the family division and the criminal division. You have to take a different approach.
Okay. Sabrina, probably starting with you, and then Judge Howsie, if you can also comment, because I'm going to start with the adult section. Obviously, having LGBTQ culturally competent judges is extremely important. Issues such as where one parent might recognize his or her gender identity or their gender identity or sexual orientation in the middle of litigation can occur. Or a transgender child might want to start puberty blockers. These types of issues do arise in adult section. How can having an LGBTQ culturally competent judge in adult section help ensure litigants or their children are supported during, their litigation?
I mean, so our LGBTQ community is victimized in so many areas of their life, right? Like in their housing, in their schooling, in their work, in their interactions with community. And so having someone who is culturally competent in that area and being willing to engage and create a trust, right, with someone who's coming into the court is going to factor immensely, I think, into how someone engages in their court case who's coming in from the LGBTQ community, and recognizing that and saying it, a message from the bench, right? I don't maybe understand, but I acknowledge that these are things that you may have been going through, and I want to talk to you about them, and I want to hear from you, and I want to believe and listen to your story. And I think that that's the first step, to have judges who are committed to doing that, who are committed to understanding someone's story or hearing someone's story, and to do it in a trauma-informed way, right? To listen, to give someone time, and to always have that message that comes from the judge directly, I think goes a long way, to acknowledging all the ways that those in the LGBTQ community have been victimized in their lives. And also to understand two things, I think, not just that a lot of things that are going on in their lives are not just related to that, right? They're related to all these other places. Where are they? Do they have access to resources? Do they, what is going on in their school? What are they facing on a daily basis? But I think also, and of course, the second thought just went out of my head. But I think it comes down to acknowledging that, all of the ways and all of their true experiences that they have when they come into the court from the start.
And so I think it's extremely important to have culturally competent judges, because you can't possibly have all of the answers for what members of other communities are facing or dealing with. And when we don't take the time to become informed, and we're not humble enough and compassionate enough and patient enough as judges to stop and ask the questions that we don't have the answers to, we make decisions that we think make sense, and they become very destructive. They can become very destructive. So we have an obligation to become informed and to ask questions when we don't know the answers. We can't always just, as judges, think because we've been gracious, life has afforded us the opportunity to wear the robe, we now have all of the answers, because we don't. And you have to ask questions. You have to ask people questions, and you have to say, hey, I don't understand this. Help me understand what you're discussing. I'm not familiar with that, because this is my thought. And tell me, does that make sense? Because it's been my experience in family division. When the parties have some input in the decisions are enforced, they buy in, things go better. They go more smoothly. But when judges just kind of do what they think needs to be done, or they do what they've always done, they don't always work as well. So I'm always about taking the time to meet with the people and the litigants and say, the children, hey, this is what I'm thinking. Let's talk about how that looks. And let's talk about the implementation of this great idea. It may not be so great that I've come up with. Let's talk about how this will impact your day-to-day and whether or not this makes sense. And I think when we do that, we get information is extremely helpful. And it also allows people to buy into the process. And I think that stops the narrative where people are always saying that the court process is discriminatory, it's not accessible, they didn't feel like they were part of the process, things were done to them, not with them. So I think as judges, we have an obligation to do that.
And
Thank you. I totally agree with what Judge Howsie said. And in addition to that, my second thought came back, which is we cannot compare cases as they come before us, right? The case that is in front of you is the case that you are addressing. You can't talk about the case you had 2 days ago and try and apply those circumstances here. You have to look at these families individually. You have to look at their experiences individually, and you have to accept the decisions and listen to the decisions that are made for that family based on the information they had and based on what was in front of them, not based on 2 cases that came before you or the day before. It's really important to talk to families and to talk to individuals in their world and what they're experiencing.
And obviously, Alyssa, I would assume based on the overrepresentation of LGBTQ youth in foster care, having a LGBTQ culturally competent judge is certainly a benefit in the juvenile section.
Yeah, there's no question. And I was going to say, because we do have this overrepresentation, and we have this overrepresentation because sadly, there are a number of LGBTQ youth who are kicked out of their birth homes, or they run away from their birth homes or even adoptive homes when they're going through some questioning of their own gender identities, and they're not getting those supports within their home. So they find themselves in these vulnerable positions when the child welfare system steps in and provides them shelter and home and foster care and group homes and such. And I was just going to say, we've learned a lot in the last few years about how to best meet the needs of our LGBTQ youth and what services are helpful and what medical care they may need and what medical providers actually work well with them, and therapists that work well with them. And, part of this too is what Judge Howsie was saying in terms of being humble and open to learning. We expect the individuals appearing in our courtrooms to change and grow and participate in services and benefit from them and change their lives. We as judges can certainly adopt the same growth mindset and continue to learn about the needs of different populations appearing before us. I mean, we cannot have a judiciary of people with fixed mindsets. We need people on the bench who are going to engage in these conversations, participate in the trainings, but truly participate in the trainings. I mean, I've been in trainings before with some on the bench, when we've been going around and giving our pronouns and have refused to participate in that, just said, I absolutely refuse to participate in this. And that's not okay. We need individuals on the bench who are also going to grow and learn and adapt to best practices and what we're learning in order to truly meet the needs of those appearing before us.
All right, well, Sabrina, one of the hot questions for our audience is about parental alienation. We know that this is a big topic, in custody with our clients are always, very concerned about this too. So if you can just explain to the audience, what is parental alienation, and how, as a judge, what tools could you utilize in trying to determine whether it's occurring, and how it would impact a custody case, if you were elected.
It's hard. Can I just start by saying, I don't think we're being honest if I don't say it wouldn't be a difficult thing, right? And there's differing opinions about whether parental alienation exists, or certainly in the scientific community, and those folks who have studied the courts and studied families, but generally speaking, we're looking at whether or not one parent is engaging in behavior that is, turning the children against the other parent, right? And we see this in custody cases, sometimes in small levels, sometimes in ongoing, engaging in patterns over time. And I think as judges, we have to look at whether or not, the first thing I think we have to look at would be whether or not the case is high conflict versus high abuse, right? And those two types of cases differ very greatly from each other, right? Parents who are engaging in behavior because they are not in a position to work together to, raise their child in a productive and supportive manner, in a very high conflict, trying to hurt the other parent as much as possible, is very different than when there is control-based violence going on in the family. So I think judges have to really look at that. There's been really many great articles written on that by the National Council of Juvenile and Court Judges, Juvenile and Adult Court Judges, and I think that is something that judges really have to train themselves on and understand the difference of. But again, I think that this goes back to understanding and hearing from as many people as possible that are connected to that family, right? That are seeing, these families engage in the community, that are seeing these children in schools. Like, school is supposed to be an absolute safe place for children, right? It's a lot of times our teachers and our school staff I view them as first responders to what's happening to children in their own homes, right? They identify, needs related to abuse in the home, needs related to mental health, drug and alcohol treatment. They see those, and they are great indicators of what's really going on. And so, this goes back to incorporating as many people and bringing as many people in front of the judge as possible to understand whether or not this is really happening. And I think judges have a duty to gather that information and look at that information in great detail and try and understand, what is really going on in this family. Because I know with cases that I've had where this has happened, it absolutely can destroy a child's relationship with their parent, right? And what we know is what's healthiest is that if children, if asked and interviewed after their parents separate, what they want their families to be together, right? If they could wave their magic wand, their parents would be back together. But when that can't happen, they need to have healthy relationships with both parents, and parents need to support that. And if that's not going on, we need to investigate from the bench why that's not happening, and gather as much information as we can.
Okay. Now, in adult court, and almost, a huge chunk of adult court matters, there's no guarantee to the right to counsel. Since we don't have the right to counsel in most of these matters, what can judges do, or do you think judges have any role, when issues come up, such as an unrepresented party who might, for a whole number of reasons, be causing unnecessary delay, or not participating in the case, and it just might really be blocking the case, and is there a role that judges can play in helping things? Judge Howsie, I'll start with you.
Absolutely. As a judge, I think and the truth of the matter is most people cannot afford the $20,000 in litigation expense associated with a divorce and or custody. So, most people don't have the money to afford an attorney. So I think as judges, we have to take the time to sit down with the litigants and explain the process. This is your obligation. This is your burden. These are the factors that I will consider when answering the question is being presented to me. These are the expectations regarding what your obligations are during this process in this space. This is what you're required to do. Tell me what questions you have about the expectations. Tell me what you don't understand so I can explain it to you. Because when we walk out of this, we conclude this hearing, I want you to know that these are the things you will need to do. And I want to make sure you have all of the information that you need to accomplish the goal. And I think when you do that versus just saying, you don't have an attorney, you're your own attorney, I don't give out legal advice, I don't know what to tell you, just make sure you're ready when we come back to court. And I think it does not create the belief and or the reality that the courts are accessible to everyone, because they're not. And you have to take the time out to educate people and be patient, and help people understand what is going on, what the process is, and what their roles, what everyone's role and everyone's expectations are, because then I think people buy into the decision. When they feel like they had an opportunity to participate, they buy into the decision versus feeling like, again, that things were done to them versus things being done with them. I've had plenty of cases where pro se litigants did not agree, because obviously one party is not going to leave there happy. Well, they did not agree with my decision, but they felt that the process was fair and they were more accepting of the decision that I made, even though they believed that I had gotten it wrong. So I just think it is incumbent upon judges to take the time to meet with people and to help them understand the process. Because if you think about it, when you're talking about divorces and you're talking about custody and adult court matters, the consequences are severe, and the space and the process is extremely intimidating. So I think as judges, we should not do anything to further that belief and further that fear, because the other thing that happens is people will withdraw and just avoid the process, and the children suffer in that space. So I think we have an obligation to be as engaging and as patient as possible to explain the information so that people can be prepared and engage in the process.
And I would just say this is a really good moment in time to remind folks that most judges who start once they're elected start in the family division, right? We have historically anyway, and having judges, I mean, you heard Alyssa give that extremely detailed and excellent outline summary of what happens in a juvenile case, right? And how would you know that, right? There's so many moving parts and so many nuances and so much detail in the family division that it's really great, I think, to consider with nine open spaces, right? To consider judges who have, or attorneys and candidates who have a family law background and who have practiced in the family division, because as you heard Judge Howsie said, this impacts so many parts of someone's life, their livelihood, their children, their homes, their financial stability. And and we all know someone who has connected to the family division. Yet in this moment of time, if you went outside and asked your neighbor, how would you file a custody case? They wouldn't know, right? That information is not easily accessible. So the second piece to this is that we have the technology and the ability to create easily accessible and easily detailed, descriptive videos and forms and websites for the public to have access to, so that they would have a better sense of how our court system works, and know what they're coming into before they get down to court, and they spend their money and their time and their dedication to a court case.
So along the same lines, Alyssa, I'll start with you. In all sections of family divisions, having a party or even both parties with mental health issues is common. Unfortunately too common. Untreated too, I guess I should say, untreated mental health issues. What role could judges play in, not stigmatizing mental health issues so that we don't, stay in that, untreated, mental health issues, or, parties are, moving towards, getting help. And they're not afraid to, be open about their mental health issues, so that we can, help them move towards getting help.
Yeah, absolutely. And it is really important that we provide those trauma-informed courtrooms that create those safe spaces for people to be comfortable to tell their stories and their whole story, including anything that they have going on with their mental health, so that we can create that space where they will feel safe to share what it is that they need to share, and also to open themselves up to services that could potentially be provided for them. Judges do have the ability to set the tone for their courtroom, to manage their courtroom in a way that's creating that safe space, and to be able to speak about mental health in a comfortable way, right? I mean, I think sometimes even our conversations can be fraught, but we can have these conversations about diagnoses and treatment and providers in a very helpful, straightforward, non-stigmatizing way, in order for families to feel more comfortable accessing some of those services. And I think also we need to be mindful of, again, those courtrooms that we're walking into, and ensuring that judges are setting the expectation that everybody in the courtroom is going to treat everybody with dignity and respect, no matter how a person is showing up in terms of their functioning on that day in the courtroom. I mean, I've been in plenty of courtrooms where I have individuals in that courtroom who are in, active psychosis. And it is, incredibly important that we treat people in a calm, caring manner, and not in any sort of situation where it would lead to anybody feeling uncomfortable or ridiculed because of how they're showing up that particular day, not in their best, because we do have a lot of people who are coming into court untreated. That's the reality. They're there in crisis. We have people showing up in crisis in our courtrooms, and we're there to deal with the crises and to help ameliorate those crises. And in order for us to be able to do that, we need to create those safe spaces.
All right, we have two questions before we move on to the next section. One is, what type of new trainings do the candidates plan to participate in themselves or suggest participation in to further educate themselves on marginalized populations, such as LGBTQ or, other minorities, or such as, I guess probably handling, becoming more culturally competent, things like that. I don't know, maybe the court, I don't know, I truthfully don't know, what the court, if the court, requires any, specific implicit bias. I've always kind of been curious if the court requires any implicit bias training and any, LGBTQ trainings of, newly elected judges, or if, just the candidates, specifically, take anything. I've always kind of been curious.
I think as judges, we have an obligation to attend as many trainings on as many topics as possible. Because if you think about the consequences associated with our decisions, I mean, these decisions are high stakes. They are impactful and they have long-term consequences. So we have to become knowledgeable about all of the issues that potentially will appear in our courtroom. LGBTQ issues, issues related to minorities, any implicit bias. I remember one time at bench bar, 1 year at bench bar, we did a implicit bias training. And I thought I was going to be accosted in the parking lot because everyone thought that we were saying that people are racist. And that's not what implicit bias is all about. It's not about racism. It's just about those biases and those beliefs and those stereotypes and those things that you have that influence your decisions. And initially when that discussion first began, it was tough talking to attorneys and judges about that. But I think that's the point. When you're making decisions about so many issues that have so many far-reaching consequences, you have to become knowledgeable and competent in so many areas. You can never do enough training. So any trainings that are available, we as judges, we should take them because they will impact the work that we do. And most importantly, they will impact the lives of the litigants that appear before us. So it's incumbent upon us to do as many trainings as are available regarding those issues.
I agree with that. And judges are public servants first and foremost, right? We have a duty to the community and to expand our knowledge so that we are serving the community. And in addition to that, we have a real problem in Pittsburgh where there are a lot of people doing real work in communities, and that work is siloed because we don't know about it, right? In individual groups, they're doing this work. And so in addition to getting the benefit of doing as many trainings as you can, you're also making networks with the communities, with people who are doing that real work, and you're bringing them as a connection and a collaborative into the work of the court. And there is nothing that wouldn't be positive about that, right? People having better trust in the court system, judges getting more knowledge, and making those connections where historically we have been siloed in Pittsburgh with that type of work.
And I was just going to say, Hilary, this, that's been the huge benefit of campaigning, which was something I was incredibly intimidated by before I entered this race. But the huge benefit of campaigning has been making all of these community connections and just building off of what Sabrina said, asking our community connections, hey, we need a training on this. Like, please develop a training for our judiciary on these issues. Like these are, and that's what judicial leadership is all about, right? Is being an engaged, informed citizen in your community, participating in what's going on in your community, and making sure that your workplace is doing the same thing, and making sure that our courthouse continues to serve the public the best way it can. And we'll be able to identify some of the, we'll have these connections with the community to say, here's what's going on. It's really important judges are educated about this. Okay, let me be a judge who wants to take the time to set up that training, and let's get it organized and let's get us all trained. So this is just an ongoing active effort that we all need to make with each other.
The other question is, in terms of differentiating, I guess, is to differentiate yourselves from other candidates running. Do any of you intend on taking any specific trainings in terms of mental health issues, so that you would be able to know what services are available to help persons with untreated mental health issues, know what services are available so that you can get them in the right services, you know, and know what's available and what's appropriate.
So I would say yes. I mean, absolutely. When it comes to mental health issues and mental health treatment, that you can never have enough training regarding those issues, because those are issues that you will see on a daily basis in your courtroom. When it comes to issues surrounding addiction, LGBTQIA issues, you're going to see those issues on a daily basis. So, you know, to talk about training, there's never enough training. You know, you have to go participate in training as often and as routinely as possible. It's necessary in order for you to be effective in doing the job. You have to continue to have training. There's no way anyone could show up as, you know, prepared to be a judge and make decisions about people's lives without learning more about these issues, because you don't come from those communities. You don't have mental health issues. How could you possibly know what the issues are and what the services are that are available? So absolutely, training is a must. And I think training that is relevant to the work that we do, it is so broad. It's such a broad range of trainings that are available, but any and all trainings, implicit bias, you name it, anything that will empower you to be more effective and capable of doing your job and lessen the racial disparities and issues that we see in our court system, we should all, judges, attorneys, we should all participate in those trainings as frequently as possible.
I agree. I think also, I mean, I would say domestic violence, because we need, you know, so much of our cases in the family division involve that. And I take trainings all the time on domestic violence, even though that's sort of my specialty work, because you need to expand that knowledge. But the other area that I would really look to take trainings in addition to what Judge Howsie said, is our trainings about our refugee, immigrant, and limited English proficiency population. I know that we had, at the women's shelter, we had hired a team of people, we call them the REAL team, refugee, immigrant, and limited English proficiency team, to do work not only within our own agency and making us more competent about cultural matters, but also to connect to those communities. And in the first few months that we had that team working, we were able to, we represented in our law project, cases where there were in the first quarter 15 to 25 different language speaking individuals. And from that, we started working with the interpreter services within the court. We expanded forms in the PFA area to be in 13 different languages, and to understand how that how folks in that community view the court, and how the services of the court are not necessarily reaching that community, I think was pretty impactful for us. So I think that's an area that we all need to focus on, in addition to all the very important areas that Judge Howsie already mentioned.
Thank you for your thoughtful answers. We're going to move on to a new topic. We touched a little bit on COVID, but I want to ask a specific question about COVID. When COVID first started, the courts shut down almost entirely. What were the specific challenges this placed on the family division, where families and domestic violence victims were often turning to the courts for immediate relief when they're within their own homes? Anyone can answer to that.
Well, for me, there were so many issues that were related to judges' ability to preside over their cases and get people answers, whether they were PFAs. I mean, because there were no in-person court hearings, so we had to rely on Teams and Zoom. But I think it was so much bad news associated with COVID. It was very destructive, and it still is. Excuse me. But the silver lining is that when judges and the system, when our backs were against the wall, we adjusted and we adapted, and we came up with ideas for dealing with cases that have been very, very resourceful. They don't impact people's day-to-day in terms of missing work, having to pay for parking, having to be absent from jobs or schools. So, when you look at that, just like in the criminal division, when you have people who are doing pleas, You know, we used to transport people from state prisons to come to the county jail for weeks just for a 20-minute hearing. So now, because we've all been forced to rely on Teams and Zoom, these things can be done in a more effective and efficient manner. Saves taxpayer dollars, conserves resources, but it also allows people to deal with these issues without being so disruptive to their lives, you know. And you talk about the costs associated with people who typically don't have the resources anyway to appear in court. And then when you add in parking and lunch and time away from work, it's very impactful. So when we look at the things that we've begun to do and we're doing them with ease and they're working, it's just proof positive. There are always ways to improve upon the things that we are doing on a daily basis. It's unfortunate that it took COVID to get us to realize that, but the good news is there are so many things now that we can do differently. Conciliations used to require everyone to come to the courthouse, have a 20-minute, half an hour, maybe even an hour meeting. Now you can do it via Teams, and everyone can do it from the comfort of their home or even at work on a lunch break. So I just think it's a game changer. And I think it will increase and improve upon that narrative regarding accessibility in our court system.
Well, and I can give you a really specific answer with regard to domestic violence, right? So when the court closed in March, we still needed access for survivors of violence to come in and file for protection for themselves and their children. And so we immediately, myself, an attorney from Neighborhood Legal Services, the PFA, unit and court administration, went into action, and we collaborated to create this entire, step in the direction of a remote filing system so that survivors could complete their paperwork over the phone, appear before judges by Teams. One in particular judge who for many months handled all of the temporary PFA hearings that were coming in. She really is one of my sheroes. She just said, we're doing this. And in the first couple months, we did 600 cases remotely. And from that, we then went on to handle the final PFA hearings remotely as well, while simultaneously working on collaborative projects to try and expand the system so that someone seeking protection can file, appear before the judge, and participate in their final PFA hearing without ever having to leave their home. And we can expand that to many other places in the court system. I mean, if you can't see my excitement about that, I'll lean further into the square. I mean, that is where we need to go. And we've seen it be so successful, even in child support cases where they were doing hearings by telephone. We've seen a 20% increase in participation because people didn't have to do all those things you heard Judge Howsie talk about in order to participate in those cases. And so I just do not want to lose this momentum. We are headed in a direction where we are looking at the true customer of the court, the person using the court system. And that's what we got to do. We can't look back from that.
Yeah, and I was just going to add, I think we learned during COVID that, we can really think creatively quickly, right? We can solve problems quickly and creatively if we all put our minds together. I mean, there's no question it was incredibly difficult the first couple of months, and we ended up with a backlog of cases in our courtrooms. And but we quickly worked together to essentially, we were on call almost, 24/7 for my courtrooms, our teams assigned to our courtrooms to at least deal with the emergencies, to say, let's all work together, figure out which of our cases are having these absolute critical problems that we need to address. We need to have a hearing for now, and let's figure out when and how we're going to get. At first, it was on the phone. We didn't have Teams at first. At first, we were doing these phone call hearings, which were really exhausting. Head to the phone, all day long. But we were there. People showed up and people pulled together and really made these happen so that everyone could still access the court and have the right in their cases. I am concerned in child welfare. I think we've seen some national statistics that child abuse has gone up during COVID, which isn't surprising given that parents have been, told in the beginning of this not to have contacts with other people. You're losing your social supports. You're losing your daycare providers when daycares were closed. I definitely saw an uptick in our serious infant injury cases in the courtroom that I was in. So that worries me a lot. And I think we need to work really hard to make sure we're supporting our parents of newborns and infants and making sure that they are not isolated and alone during these, really difficult mental health COVID months on top of dealing with a newborn for the first time. So.
Thank you. Okay, we're going to move on with just like some miscellaneous questions. The first one is, since we've had a group of candidates who have discussed some progressive issues in other forums that we've done, I want to know whether we can both have restorative justice for offenders while also being strong on domestic violence and abuse. How do we mesh these concepts?
I'll hop in first. So I will tell you about a project that's happening right now that I think answers that question directly on point. So I have been working on a collaborative project with the amazing folks at DHS to take what we have in Allegheny County called the Batters Intervention Programs, which are certified trainers and educators and counselors working with batterers to try and change abusive behavior in PFA hearings. So it had been that those programs had generally been in the criminal division and in criminal cases, which is an excellent restorative justice program for the criminal division. But moving it over into final PFA hearings, we're at a place where judges can decide that there's been abuse in that case and someone needs to be protected, and a final PFA order should be entered that protects that family, but then also direct that the perpetrator of violence participate in the Batters Intervention Program, in this restorative justice program, right? So that message from the court is saying we want to put protections in place. We care about keeping families safe, but we don't want this abuse to continue to go on. We want to try and change behavior. We want people to feel accountable and that they have power over their own their own behaviors, and that's going to change the way not only that family operates and that family interacts, but the way that those individuals act within the community and engage in the community and reducing violence, right? Because what we know about folks who are victims of violence is that they just want the violence to stop. Most of the time, they're not asking for punishment. They're not asking for sanctions. They're not asking for incarceration. They're asking for the violence to stop so they can move on safely in their families. And having those two paths unite, Batters Intervention Programs and final PFA hearings, is making that kind of impact and change. And I'm really proud to be part of that collaborative effort to do that kind of work. And that's just the start. Again, I'm excited, but that's the start. Well, that's the paths we need to be taking. That's the real change we need to make.
Yeah, and similarly in the child welfare world, because Sabrina's working so hard to get these programs established and the word out. And part of what I've been doing is making sure that our caseworkers are making sure that when they're doing their family service plans, is that they're referring any of the parents on their cases who could utilize the Batters Intervention Programs, referring them to them, making sure that they know about them. And you have in Allegheny County a pilot project on improving domestic violence and child welfare that's working with the Federal Department of Health and Human Services to improve practice here. And it has really helped with casework practice in terms of ensuring that we're not only serving victims of domestic violence, but we're also serving the individuals who are using violence and providing the service to them. Because when you have children involved and you have two parents who are going to be your parents for the rest of your life, you need both of those parents to be healthy and whole and engaging in services. And unfortunately, for the longest time in child welfare, we were so focused on the individuals who were victims of domestic violence and not so much the individuals who were using the violence, that we left so many people out of the conversation, and we were only solving, maybe half the problem if we were lucky. So there's really tremendous work being done in the county to ensure that we're addressing all of these issues within the whole family and working hard, especially when we're looking at sometimes our fathers not being engaged as much as they should be in our child welfare programs, and caseworkers not reaching out to them as much and not engaging them in their family service plan. plans as much. So a lot of work being done around fathers and batterers intervention programs, and ensuring that those who are using violence are getting this, getting help as well.
I think that with restorative justice, it's all about giving people an opportunity to move on after having become involved in our court system. And whether that's because of the way in which we impose conditions of bail, whether that's because of the way in which we require perpetrators of domestic violence to get involved with counseling and or treatment, or whether that's because, after, sentencing them to a period of incarceration, the things that we do to allow them to move on with their lives. I think that's restorative justice as well. So I think, just overall, the court has an obligation to give people the necessary tools and equipment to do better and be better. And with domestic violence, first things first, you have to ensure the safety of the victims of domestic violence. That's non-negotiable. But next, what can we do to create a situation where it lessens the likelihood that there will be repeated violence, or it lessens the likelihood that this person will continue to harm other people, and then afford that person the opportunity to move on, whether it's having meaningful employment, whether it's, not imposing a sentence that will destroy work opportunities, or imposing a sentence that will, while holding the person accountable, will also allow the person to get the help that they need to lessen the likelihood that they come back. So I think that's what restorative justice is to me, is all about creating situations where people can move on, but still be accountable.
Can I just say this too? It's really important, I think, what Judge Howsie said, which is that it is the court's obligation to be able to provide these resources for people, that we cannot just send folks out there and say, do this, or why didn't you do this, right? We have an obligation from the court to try and create those resources and connect people in their own neighborhoods and in their own support systems to what they need in order to make the changes or take the improvement steps that they want to take in their lives and their families. And I hope that that's where we're heading in our courts.
Thank you. In our panel last week, Tiffany Sizemore, who is another Court of Common Pleas candidate, made a comment that she understood that the Black community had trauma about police and coming to court, but she was asking them still to come to court for their community. We thought this was a very powerful statement. In the adult section, custody proceedings, judges will often say, well, why didn't you file this sooner? And almost penalize a litigant for not coming to court sooner. Do you think judges can play a better role in understanding the challenges that it might take a person in getting to court?
I would say yes, absolutely. I mean, it's just like with domestic violence. I believe there's a statistic out there, and I may be wrong, and I'm sure if I am, Sabrina will correct me on this, but I believe that people will leave the home of the abuser somewhere upwards of 13 times before they finally decide to leave permanently. So with that being said, there are a million reasons why a person may have chosen not to file or may have chosen to not come to court sooner. I don't know that that's really the issue, or is it as relevant as the question is, now that you're here, what are you seeking, and what are our obligations in terms of what we can and cannot do to address your question? I don't know that matters about what took you so long, whether it was a fear of the system, whether it was your lack of resources, whether it was your inability to get off from work, whether they were issues with childcare. Who cares? You're here now and you need help. So let's figure that out and keep moving. I don't know that matters. So.
No, I agree. And how about this? What if we change? I mean, I will say this with my clients, I experienced that same resistance and concern and fear of calling the police when you need protection because of a concern of what's going to happen if you do. So I recognize that absolutely as a barrier, as a systemic problem that we as a society in all parts have to focus on and fix. But in the meantime, let's turn that question around and say, why can't our courts come to you faster, right? This is an opportunity where we could really, we see judges trying to get back into the community to handle their cases, within the communities where people are accessing the court. And so what if we could make a complete change where instead of expecting people to come to the court system, the courts came back into their communities, and we have these locations across the county where people can file and they can access the judge, and the judge can see litigants within their own communities. And I think that would go a lot to issues of implicit bias, issues of understanding resources, and issues of making sure that people have access to what they need in order to make themselves safe and productive and stable in all areas of their lives. So I don't, we should never be asking anyone those questions, but we should also turn it around and say, what can we do to get to you a lot easier?
I like that. Thank you. Thanks for hanging in there to our panelists and our attendees. We have a couple more questions regarding some citizens' reviews of the adult section of the family division. Most report a negative experience with how the division operates. There are reports of unreasonable delays, difficulty in receiving information in a timely manner, being unable to reach anyone on the phone, like no one picks up, or the line is always busy. There was also reports of gender bias, inconsiderate judges who focus more on child support rather than child welfare. The overall assessment of those who interact with the family court is that judges just don't care, and the division is dysfunctional. As a judge, what can you do to ensure that those who interact with the family division have an effective, responsive, and fair experience?
So, go ahead. I'm sorry.
Oh, no, it's okay. I was just going to say we really need to ensure that as soon as individuals walk through the courthouse door, they feel that there's people waiting there to answer their questions and meet their needs. And we don't have that currently. I mean, unfortunately, we still have, it's not surprising that people delay filing and making requests of the court when it's incredibly intimidating to walk down there. You go through the security, which is expected, obviously, but people can still be polite and friendly in the security line, and that often doesn't happen. And we have really poor signage. A big complaint of mine is that for our juvenile cases, we have a whiteboard listing the judges in the courtrooms, and I mean, it's located behind the sheriff's desk, and how, we expect people, the first thing they do is they have to approach the sheriffs and try to figure out where they're going. I mean, that's intimidation upon intimidation upon intimidation. So we can do a lot to just make the courthouse more user-friendly from the absolute get-go, from the first few steps in the door. And then obviously, issues like phones not being answered. I mean, judges need to take leadership around those. If we're hearing those kind of complaints, then we need to start asking the questions of our own administration. How can we problem solve these? We can't have phones going unanswered. I mean, again, as Sabrina pointed out, the courts and judges are providing a public service, a service to the public, and we need to hold ourselves accountable to much higher standards and expectations, and ensure that we're actually meeting people's basic needs of answering their basic questions about what's happening in their courthouse for their court day.
I believe additionally, we have an obligation to treat people how we want to be treated. If you were a pro se litigant trying to navigate through family court to file for custody, would you want to be treated in the manner in which the people are routinely treated? If you were a pro se litigant who was in a custody trial and you didn't know the first thing about the practice of law, but you're just trying to advocate and get custodial rights of your children, how would you want to be treated? And if you as a judge were sitting on the other side of that table, what would your expectation be? So I think we have to be patient. We have to be tolerant. We have to explain the process. We have to make sure the process is accessible. And if you've explained it 3 times, explain it 3 more times, because people need to understand it. They need to understand what is going on, what the obligations are, because if you do that, people will feel that the process was fair. They'll feel that it was accessible, but most importantly, they will be more respectful of your decision and accepting of your decision. So we have to do that. I mean, if we were to take some of these judges, myself included, and pick me up out of family division and put me over in orphans court to represent myself, or another person in an orphans court matter when I have very little orphans court experience, what would I expect? What would I want? From that judge. So we have to keep that in mind and in the forefront of our behaviors and our manners when we're interacting with pro se litigants, when we're interacting with people, when we're dealing with PFAs. There are 2 sides to every story, and you need to make informed decisions. And that means everyone needs to be heard in all matters. And so I just believe as judges, it's an important job, and you have to have all the information before you're making decisions to have such long-term consequences associated with them. So I just believe as judges, we have to do better. As court staff, we have to do better. People should not walk in that building and feel like they're going to get the run around or get the short end of the stick, or the process will not be fair, or the game is over before it even begins. That is unacceptable, and that's not what we would expect if we were on the other side of that table.
I agree. I mean, the true customer of the court is the public, the folks coming into that court system. And if that means that judges and court staff have to be inconvenienced, then we have to be inconvenienced. I know I'm going to be tortured for this, but I'm going to say it out loud anyway. We have, I think it's 17, well, under normal circumstances, we have close to 17 judges in the family division, and each one of those judges does things differently. They have differing operating procedures. They need to come together. We need to have similar and same procedures for everyone coming into the court so they're easy to understand, and we need to make a commitment to that so people know what the procedure is. I, as an attorney, sometimes don't know what the procedure is in the family division, and that's not okay when I'm engaged in there on a regular basis. We need to make our procedures in our court clear and accessible and easy to understand, and the same no matter for who's coming into the court system. And we have a lot of work to do to get there. And people, that means something to people. They're already struggling with many other reasons for why they're not accessing the court system, but the procedures should be easy to understand at all levels in the courthouse.
Thank you so much for your impassioned and informative answers. I'm going to turn it back over to Hilary.
All right, so this is the part where I'm kind of like a game show host. All right, so now more and grassroots justice are advocacy groups. So this is where we ask, all of our listeners, both here, in the Zoom and who will be watching the rewatch, to support these candidates, because we specifically ask candidates who come on here to do this because we want to support you. So Alyssa, let's start with you, and why don't you tell everybody listening what events you have coming up so they can come. I assume that you have some canvassing coming up, or possibly some meet and greets. So if they want to learn more about you or help support you, why don't you tell everybody what you have coming up?
Yeah, sure. Thank you, Hilary. And first, everyone can go to my website, votecowan.com, to keep up to date with everything that's happening with the campaign and to volunteer. If you're so inspired, this Saturday at 11 a.m., we'll be meeting in Squirrel Hill with Erica Strasburger and Brian Malkin, who's another one of the candidates for Court of Common Pleas, to do some canvassing together, which I'm super excited about. I love joint canvassing. It makes it so much fun, and it's a great way to hang out with people in a COVID-safe manner outside, masks on, get to see people, get to actually talk to people. So we'd love to have you join us for that. Hopefully the weather will be good. I haven't looked at the weather forecast yet, but hopefully the weather will be good. So we'd love to have you join us for that. But then obviously, go to the website in case you want to do anything else, make phone calls or canvass on your own. Thank you.
All right, and her website is in the chat, and they can't request, well, Alyssa can't request it, but I can. If you want to donate to Alyssa, you can go to her website and donate, because these candidates, as I will repeat after each one, are obviously going to be blasting commercials soon, and they will need money for these commercials. So we ask everybody who's listening to donate to these candidates because we want to support them. So, all right, Sabrina, tell us what events you have coming up.
We too are canvassing and text banking each and every week. Last week I walked 30 miles.
Oh God.
So it's great to be out there talking to folks, as Alyssa said. And if you haven't had the opportunity to text bank before, it is super fun. You get really interesting interactions and feedback. And so you can sign up for any of those things by going to my website at sabrinaforjudge.com. I would, from my heart, truly truly be appreciative of anyone who wants to volunteer in any capacity that works for them. It's a difficult time to get the word out about these really important elections. These forums are great, but talking to folks about our campaigns and particularly the importance of the family division and making holistic changes in the court is really super important. So I want to use this time to say thank you, but also thank you to anyone who'd be interested in helping. I would greatly appreciate it.
All right, and again, Sabrina's website, Sabrina for Judge, is in the chat, and you can go there to donate to her campaign, so you can see her commercials. I've seen them; they're
Yay.
very cute. So you can help get those on the air. Judge Howsie, what do you have coming up?
Thank you. So this Saturday, April 24th at 11 a.m., we're going to do a canvass in Carrick with Representative Jessica Benham. Saturday at the same time, we're doing a rally in Moon Township with the Democratic Committee. On Sunday at noon, we're doing a canvass with the NOBO Progressives. And those events and many more are all listed on our website. There are opportunities for volunteering. Any form of support is appreciated, whether it's door knocking, you know, you name it. We have yard signs. So we're just so excited about the support we've gotten so far. And we were just humbled by the support, but we're also appreciative of any support that we get going forward. So if you're interested in learning more about the campaign or opportunities to volunteer, please look us up at elliothowsie.org. And thank you so much for this opportunity, as well as your efforts in putting this together. So thank you. Thank you very much.
All right, and I will ask for the financial support. And you can give financial support to Judge Howsie at his website, which is in the chat at elliothowsie.org. And all three of them again are in the chat, or which you will be able to rewatch if you want at the event site, or lebofightsracism.com, or Grassroots Justice pages. Please join our groups. Our organizations are active in various social justice initiatives in the South Hills. So thank you, everybody. It's been fun.